SJC-09926, Commonwealth v. Thomas Lally.
May it please the court, Catherine.
One second.
Catherine Hinton for the defendant, Thomas Lally. This is a case in which bought and paid for testimony of a cooperating co-defendant was buttressed by deliberate misuse of inadmissible DNA evidence, combined with serious mistakes of trial counsel to produce a conviction that should not be permitted to stand.
Would you mind, because I just cannot get it straight in my head, just sort of outlining what the difference is between the clippings and the scrapings and which ones had YSTR testing that did whatever and which ones had just STR testing? I just...
Sure. The right-hand scrapings had STR testing. Non-exclusion test results were submitted without statistics. The right-hand clippings had YSTR testing, which were also non-exclusion results submitted without appropriate statistics. So it's both on the right hand.
So it's all on the right.
It's all on the right hand. It's
one
the
of them
right hand
has-
scrapings is standard STR. The right hand clippings was YSTR.
And with regard to the YSTR, what was the testimony with regard to that?
The testimony with regard to YSTR was that YSTR is very different from standard autosomal STR testing, so that there's a database of collected individual samples. And all that is done is a counting method, looking at the database and counting how many times the haplotype is observed in the database. That number was given at trial by the Commonwealth's expert as 0 out of 1,108 African Americans, 0 out of 894 Hispanics, and 1 out of 1,311 Caucasians.
And you say that needed to have a confidence.
That needed to have a confidence interval applied to it in order to convert the raw count of the database to a frequency estimate in a population. So when the conversion is done, instead of 0 out of 1,108 African Americans, you get 1 out of 369 African Americans.
So let me just ask you that. If the confidence interval is applied and you get a frequency within the population, so then that makes it, if I have this correctly, that makes it somewhat equivalent to the statistical information that you get with respect to STR testing.
You're extrapolating from a database of known samples, which is simply a collection of individual samples that's getting bigger all the time, and at the time of this trial, it was a rather small database. You're extrapolating from the database by applying a confidence interval, which is you're stating that you're 95% confident that the actual number will be within these bounds. So Dr. Cotton at the evidentiary hearing called it bounding. Dr. Burke called it a correction. There's scientific literature that's in the record that calls it a correction. This court has previously described it in Bazanowitz and Evans as using the confidence interval to extrapolate to the population. So without a confidence interval, you have a number which I submit is quite confusing. 0 out of 1,108 African Americans, 0 out of 894 Hispanics, and 1 out of 1,311 Caucasians. That's not a real estimate of the frequency in the population.
So when you do the confidence level, then you're saying that it's like you do with just straight STR, that the likelihood that a random person would be found in this group is 1 out of whatever of the population.
Right, 1 out of
the
in this
African
case,
American.
hundreds. And then if you put it into context of an actual population, Dr. Burke testified at the evidentiary hearing, you end up with nearly 7,000 people in Massachusetts who have this exact same, who would be expected to have the exact same haplotype as Mr. Lally.
You mean if you multiply the one out of whatever
Yes,
into the population of
if you look at the census figures of either Quincy or Massachusetts, which is what Dr. Burke did at the hearing, you can show that this is a common haplotype, that the thousands of people have this haplotype in Massachusetts. You could extrapolate it, you could expand it, and look at the census of the United States and come up with additional numbers.
Could you help, though, with this? The defense was that one fellow, not an unknown number of people who were possible candidates, but one known person where did it. And I thought he was excluded under both of these.
Yes, but
Was he? Well, is it
Okay,
true
so
that he
there's
was
two-
excluded under both these?
yes, he was.
Okay.
Okay, so there's two issues that I've raised. One is that had a timely trial objection been made, neither of these two forms of testing should have been admitted at trial, which would wipe out the entire thing. Then I've made another argument that even if you don't end up excluding all of the DNA evidence, trial counsel didn't work with the evidence that was before him to attack it in any way. And that gets to your question of, well, what kind of relevant attack could he have made? And I would argue he could have, there was a contamination issue about a different piece of evidence, and it would have dovetailed neatly with his contamination defense that this is a common haplotype. There had been testimony by the Commonwealth's expert that contamination can happen anywhere along the way in the process. It could have been contaminated, during the collection process and so forth, or that the victim could have had this DNA under her fingernails from some other source, even though she was elderly, she was active, she was in the community, she was, could have picked up DNA under her fingernails in some other way. So I think there are uses that trial counsel could have made, even if the DNA results were admissible, but I don't think they were admissible. I think that
So let me ask you, if it had been calculated, would it have pointed away from the defendant?
Well,
That have been
the only evidence we
exculpatory in
have is the summary report of Dr. Burke, and he testified also at the evidentiary hearing that the numbers on the STR would have been within 1 in 10s or 1 in 100s. We don't have an actual calculation.
What does that, I'm sorry, what does that mean? What's the answer to Justice Hines' question?
It would have been much more frequent.
It would have been frequent. It would have been much more frequent than the jury would assume by no statistics having been given. In fact, the expert testified at trial that, if we were able to cleanly pull out a profile from this mixed sample, you would have a very large number. So you've got the problem that has been identified in Mete, that was recently identified 10 days ago in the Cameron case, which I submitted a 16L letter to the court about, that there was a high likelihood of jury confusion, and that jury confusion is exponentially increased when you add the prosecutor's misstatements during the closing argument.
You fault counsel for not raising this issue, but Mate was 4 years in the future at the time that this case was tried.
I would say a few things about that. I would say that the prior legal precedent, Kernan, Daggett, Rosier, culminated in Mate. Certainly the line of legal analysis was already there. Mate's case was in 2004, and Mate's counsel thought to raise an objection that this would be more prejudicial than probative to submit non-exclusion evidence without statistics.
Mr. Lally's counsel doesn't know anything about what Mate's counsel is doing.
Well, all I'm saying is that the Commonwealth has never even raised that trial counsel should not have been expected to
Well, no,
make
you
this
say it
objection.
was ineffective assistance of counsel, and you put that together with a whole batch of things that you say counsel didn't do. And I'm just trying to zero in on this one particular thing and ask you to tell me how counsel was supposed to figure this out.
Well, because Kernan, Daggett, and Rosier, and a number of other cases had all talked about DNA results should not be submitted without statistics. And Matei was simply an extension of that body of law, and it clearly was more prejudicial than probative. Trial counsel should have made that objection.
But this wasn't the kind of DNA testing that was going to give you a match in the sense that it's him.
Oh, now you're talking about the YSTR. Well, the YSTR, so for example, there's an extremely well-known treatise, which is an excerpt of which is in the record at, I believe, 810, John Butler's treatise on DNA, which has a whole chapter about YSTR, which says that the YSTR database should be considered qualitative rather than quantitative. It's not an accurate, the raw count is not an accurate estimate of the frequency in a population, and a confidence interval needs to be used. So that's one source. The other source is the expert
And that existed before.
that exists. That's the 2005 version of that treatise, which existed before the 2006 trial. The other source that he should have gotten that information from was his own expert. He got funds for an expert, he hired an expert, but then he decided not to use that expert. He used that expert only to try to run down this issue about contamination of the perianal swab, which was it was a reasonable thing for him to investigate, but it turned out to be mostly a red herring, and it wasn't the only DNA issue in the case.
Well, going back to Justice Link's point, there wasn't anything for the expert to do in this case, given the defense that it was where. I mean, the focus of the case wasn't really the DNA evidence, was it?
Well, I disagree with that. I think that that trial counsel should have used the expert. The expert put in his own summary report that ordinary STR DNA is not admissible in many jurisdictions without statistics. And trial counsel never followed up on that to keep that test result out. He never asked Dr. Burke about YSTR at all. He was a former prosecutor who had only worked with DNA a couple of times and had never had a complex DNA issue, and he didn't know very much about DNA. His testimony at the evidentiary hearing was that he basically decided, since it was not an identification match, it was not something he needed to worry about. He really misunderstood what DNA test results are all about. A non-exclusion is also inculpatory of the defendant, and he should have been trying to do anything he could to keep that evidence away from being admitted at the trial, and he didn't do that.
Thinking of it, could you send a letter with a citation to the treatise that you were referring to?
Certainly, although I do believe it's in my brief as well.
Looked at it, and I don't see it cited in your brief.
It's in a footnote.
Oh, okay.
I don't remember the exact page. But I can certainly send a letter to clarify.
That's fine. I was looking in your, at the beginning in your citations.
So my primary argument about the ineffective assistance with regard to DNA is trial counsel should have made a timely trial objection to keep this stuff out.
But you also say that it need not have been made through a motion in limine. I mean, part of the concern I have is that the message for defense counsel is don't raise it in a motion in limine, although the world would be better if you did, because that would give the prosecution the opportunity to go back to the DNA expert and be able to give numbers, do it at trial where there's no opportunity and no time for the Commonwealth to fix the problem.
Well, Your Honor, I mean, ordinarily, trial objections are made at trial. There's only certain, Lanigan motions have to be made pre-trial. I would point out that in Matei, the objection was a trial objection.
I'm aware
and
of
this
that.
court found that that was sufficient to reverse the case. So, while the Commonwealth might not like it, it's certainly within the defense's rights to make a trial objection. And if a trial objection had been made, as this court said 10 days ago in Cameron, it should have been sustained. And the Commonwealth wants to take this tiny footnote in a case called Tassoni to say, well, The Commonwealth could have come up with the statistics if trial counsel had made the objection.
Well, let me even ask you that, though. It seemed to me in this particular case, that was a doubtful proposition, given that the lab had closed.
Yes, the lab had closed. The statistics were not in the case file. The expert could not have just opened the case file and read them off. The expert had stated that it was the policy of the lab not to provide such statistics in mixed cases with regard to STR. The lab had closed. The lab director had moved on and was, as she put it, distracted with trying to get a new position. It would have required additional research in the field to figure out what the appropriate statistic would be, and all of this would have had to have occurred in a 2-day span of time between the time of what I say is the missing objection and the time the Commonwealth's case closed. I think it's extremely unlikely that it would have been done.
Right,
Could
no,
it
I
have
mean,
been done? Could it possibly have
I
been done
get that with regard to
theoretically?
with the STR. How about the YSTR?
Same with the YSTR. The testimony was that it would require additional research. That's what Dr. Cotton said at the evidentiary hearing, that it would require additional research to figure out what the appropriate confidence interval would be and to apply it.
Now, in terms of the issue of prejudice, let's assume you're right, that it should not have come in. The argument would be, given that the whole defense was that it was me or Weir, what was really most critical was that Weir was excluded.
Well, I would say, as in Cameron and other cases that Cameron has cited, the DNA evidence here acted to tip the scales in favor, in buttressing the credibility of a key Commonwealth witness. So the key Commonwealth witness is Weir. His testimony was the linchpin of the case. The case, it doesn't have much else. It's got some ambiguous scratches, some ambiguous statements, and Weir is really the key. And so when you take DNA results, which have been pumped up artificially through this misleading closing argument by the prosecutor, and you pump up Weir's testimony with that, it's enough to push it over the edge and tip the balance in favor of a guilty finding rather than an acquittal. So I think there is definitely prejudice. Remember what the prosecutor said in closing argument. It was just inexcusably misleading. She said, now he matched them up, and you can see that. Now it's a matter of semantics, ladies and gentlemen. He told you at Selmark they don't use the term match. That's exactly what it is. This was a certain type of testing. It's paraplex, different testing than PCR and STR, the first type of testing. It may sound confusing to you, but what it comes down to is they just don't use the term match. But if you look at it, you'll see that all the numbers from Lally correspond to the fingernail clippings. So she's basically telling them it's a matter of semantics. YSTR, we know from the testimony, and everyone agrees, YSTR can never identify anyone. And the prosecutor says to this jury that it's a matter of semantics, that the difference between YSTR testing and other types of STR testing is a matter of semantics. They just don't use the word match, but really that's exactly what it is. So I think that it's extraordinarily prejudicial and did act to tip the scales in favor of a conviction.
Matei, of course, is not confidence interval, but it's just STR or whatever. So you say Bazanowicz is a confidence interval case?
Well, this court in Linton declined to decide whether Matei would apply to YSTR cases, because in that case it was a husband-wife case, and the court went on to find that there would be no substantial likelihood of miscarriage of justice, even either way. Carnes is a case about mitochondrial DNA, which is very similar to YSTR. It's the female component as opposed to the male component, and same thing. The court declined to actually answer the question. Bazanowicz and Evans, it's not the issue that the case is decided upon, but there is language in both cases saying that the confidence interval was used to extrapolate from the database. And I think now this case is perfect opportunity to clarify this point. I haven't found other cases in which the confidence interval was not applied.
The point being that it's admissible only with the confidence level?
Yes. I think that, as Dr. Cotton stated in that the evidentiary hearing, YSTR was in its infancy at the time of this trial, and I don't think this will come up very much in the future, but it certainly came up at this trial. The other big issue in the case is the admission of the tape of Weir talking to his friend Morell, I think it was inexcusably ineffective of counsel to submit that tape.
Can you tell me what it was that the jury heard on the tape that they didn't know already or get from some other source?
Well, one of the things that I would complain about is they heard Lally suggesting killing a bum, saying, I got a taste for it and I'm kind of liking it, and suggested with regard to a particular homeless man that they had come along just effing slice his throat, while Weir says, dude, don't go there. So the jury is getting additional bad acts about Lally from this tape, and they're getting a real beefing up of Weir's testimony about the gruesome details of the killing itself. They're getting a prior consistent statement, a lengthy prior consistent statement. I mean, it was shocking to me that trial counsel put that evidence in. So I just want to make one last point about cumulative error. So the mistakes in this case were numerous, but most of them buttressed Weir's credibility. So the DNA evidence buttressed Weir's credibility, the tape buttressed Weir's credibility, the unredacted plea agreement buttressed Weir's credibility, and then the other mistakes all acted to decimate Lally's character and credibility in a case in which the evidence was not overwhelming. Thank you.
Thank you.
Good morning, Your Honors. Pamela Alford for the Commonwealth. I would like to start this morning with the overwhelming nature of the evidence. This was not a DNA case. This included the defendant's statement after the crime that it was the perfect crime. We did it. It was no sweat. The defendant made a number of statements before the crime advocating the victim's demise, that he was going to hit her over the head with a blunt object and leave her at the bottom of the stairs, that he could have strangle her or break her neck without causing bruises. A number of witnesses 6 months before, a couple of weeks before, a couple of days before. This was a case where a co-defendant whose case had been severed, Anthony Calabro, the victim's great nephew, got into a car accident. He said, he wanted 2 days before the murder. And he said he wanted the victim dead. The defendant said, well, that can be arranged, or that Anthony Calabro said he wished the victim would just die. And the defendant agreed. It could be inferred that the defendant's car was at the scene. The defendant was at the scene when Anthony Calabro called police that night to report that his elderly great aunt had been found at the bottom of the stairs. He was nervous. He admitted that he lied to police. He had scratches on his face. And at the end of the day, nothing that the defendant would ever do as to the DNA, which the Commonwealth will address and contest, is going to change the fact that the defendant was found with scratches on his face, a bite mark on his arm. Anne-Marie Calabro testified that the defendant walked by her that night, red and flushed, with his hand up to his face. The jury could infer he was trying to hide his face. Then both to the police, he said that Anthony caused the scratches. To his friends after the crime, he gave a number of inconsistent statements of how he got those scratches, saw immediately after the victim's death, that his dog Mace did it, that Anthony did it with a bottle, that they were fighting, that they were wrestling. It also, Weir's statement was corroborated in a number of ways, not the least being the medical examiner. And I would suggest looking at the prosecutor's closing argument, where she talks about now Weir and Lally both accused each other. They had differing views of how the crime was committed, and Weir's testimony was that Lally was holding his hand over the nose. The medical examiner found a contusion on the nose, that Lally was holding the victim up against the stove, and the medical examiner testified, while admittedly originally finding that it was an accident, testified that there were hemorrhages in the small of the victim's back, that Lally had his arm around the victim's ribs, and the medical examiner testified to the number of ribs, that the medical examiner testified as to why he might not see evidence of, why not all cases will show all the evidence of strangulation, but there were hemorrhages to the right side of the victim's neck, and Weir testified that she was hit with both a frying pan and a tea kettle. So this evidence was multifaceted and overwhelming. It also includes the defendant lying to police on the night of his arrest, October 25th, 2002. This wasn't a DNA case. But turning to the DNA,
Can I just stop you for just out of curiosity? Whatever happened with Calabro's case?
it is cited in the Commonwealth brief after defendant Lally's trial. He pled guilty to second-degree murder.
Okay.
And where is manslaughter 10 years?
No, and this is also cited in the party's brief.
I know it is, I forgot.
He was indicted on a charge of accessory after and pled to, it was like 6 years, 11 months to 7 years, to the top of the max. I'd like to address Justice Botsford's questions about DNA because there is a fundamental misapprehension about what a confidence interval is. It is not a frequency. It is a bound. A confidence interval is a statistic that the defendant wanted applied to this evidence. And if I could go to what Dr. Cotton testified at the trial of how she would have presented this evidence, that the raw count is an estimate, that anytime you look at what the parties, anytime you make a count that you're not counting the whole world, it's going to be an estimate.
And so that's what, is it Hickey? The expert?
Hickey did the raw count.
And that's what he testified to?
Yes. And he also, and I think this is very important, clearly explained what he was doing to the jury. But Dr. Cotton testified, I would have expressed it to the jury as explaining that there is a database, that the number of Caucasian individuals of the database is third, 1,311, and when we looked through all those Y haplotypes, there was one that was the same haplotype from the evidence in Mr. Lally, and if I use that as my estimated frequency of how often I've seen that haplotype, then I can create a confidence interval for that number, similar to the testimony that I gave a few minutes ago that says I'm 95% confident that I sample other Caucasian databases, and I repeatedly did that the frequency would not be smaller than that, is less than 1 in 443. It's not a frequency. It's not the same as a random match probability. Dr. Cotton testified it was inappropriate just to substitute the number, that if a confidence interval was to be presented, both numbers would be relevant. And going back to Hickey's testimony, Hickey clearly talked about what a confidence interval could and could,
Wait, when you say both numbers, you mean both the raw, the estimate? What do you mean? What both numbers?
Both the raw count, that the sample, that the profile was seen 1 in 1,311 times for the Caucasian database, and if you were to do a confidence interval, what the 95% confidence interval is. And I think this touches on a number of points. This profile, and this was clearly testified to by Hickey, was already in the database when they were looking at it. The jury couldn't have thought that it was a max because Hickey testified, so there was one other occasion where, as to the Caucasian population, that the profile that was consistent with the defendant and the evidence was seen in the database. Hickey clearly testified as to what YSTR and STR was not. And moving on to the STR evidence, and I do want to note that there's right-hand scrapings had STR, that the right-hand clippings had both STR and YSTR. And in this case, while there was admittedly not statistics done, the context of this case, that the jury would have seen this as a step in the process. The fundamental difference between this case and Cameron and Cowles is in those cases, the DNA, the inconclusive result, or the result that was later found not to be appropriate, was an independent piece of DNA, and that was the same in Mattei. Here, Hickey took pains to say, well, I did the STR testing on the scrapings. He appeared on a few of the secondary profile. And then he explains why STR testing isn't very good. And he also says, as to right clippings, that he gets a mixture. He couldn't pull out a profile, but Weir and Calabro were excluded. Does not mention the defendant at that time. And he says, and he basically says, look, this was fingernail scrapings or clippings. When you test the victim's fingernails, you would not expect that, you would expect that you're going to get mostly the victim's DNA. So we did this other testing, YSDR testing, because it eliminated the mixture. So this is not a case like in Mattei, where there was some ambiguity, some uncertainty that the jury could think that the term, the match or the non-exclusion, meant that the defendant matched, that the defendant had numbers, had these astronomical numbers. Hickey, in fact, testified that if they could have pulled out a profile, that then they would expect astronomical numbers. But they couldn't do that, so they did the YSDR testing again. And again, we're talking about the right-hand scrapings and the right-hand clippings. In totality, this was presented as one piece of DNA evidence. At the closing, the prosecutor talked about the right clippings.
But she did say match, both in her opening and her closing. She kept talking about a match, and that wasn't the evidence, was it?
I don't believe she used the word match in her opening. She did say, I do agree, she did say whose DNA was underneath the victim's fingernails. That was a stray comment that was corrected repeatedly at closing, where she...
Corrected? By whom?
The prosecutor at closing repeatedly said could not be excluded.
But isn't that where she talked about, they don't use the word match, but they really mean it?
In the context of this is very important. Hickey testifies as the difference between STR and YSDR testing. And at one point in his testimony, in talking about YSDR testing, he says, in looking at the defendant's profile, it matched at all the regions tested. Counsel then in crosses impeaches him on, well, you didn't use the word match in your report. And then that was brought out on redirect of the differences between YSDR and SDR testing. And so closing argument, counsel, whose strategy as to the DNA was to say, look at the contamination of the perianal swab, look at all the problems in the police investigation, don't believe any of this evidence, impeaches Hickey by saying the first time he uses the term match was in his report. This gives the prosecutor some ability to counter that, and as the motion judge found, permissibly talked about that the match was as to the regions, not as to the conclusion. I do agree that she should not use the word semantics, but that only goes to highlight Hickey's testimony that talks about the differences between SDR and YSDR testing. The other important things to differentiate this case from Mattei, there are 3 important points. One, the chart went into evidence in Mattei. It did not go into evidence here. It was neither evidence or marked for identification, but with the permission of the judge, was used during closing. 2, that in Mattei, the prosecutor used this evidence to say this is that the victim's DNA was on the defendant's sweatpants. There was no such extrapolation here. The Commonwealth prosecutor appropriately confined herself to saying whose DNA could not be excluded from the victim's fingernails. And even in Mattei, there's a comment where they said, we're not going to address the part where, we're not going to address whether not putting statistics for one sample is inappropriate when there are statistics on another testing of the same sample. And while I recognize these are different sample, you're talking about the right-hand scrapings to the right-hand clippings.
You can't. You're suggesting that there's statistics for YSTR, but not for STR, and we should just mush them together? Is that what you're saying?
In terms of a substantial likelihood of a miscarriage of justice, that the prosecution, who only spent about 2.5 pages out of its 22-page closing argument on DNA, talked about the clippings. There was not an attempt to say, look at the different samples, extrapolate that it must be him. The scrapings were really a step in the testing of how we got to the YSDR. I'd like to talk about the need for a confidence interval. This should have been raised in a motion in limine. If you look at, I believe, counsel's brief, they talk about that a motion in limine is used to prevent there from it denigrating into a contest of experts. But if you look at the post-conviction evidentiary hearing, that's exactly what happened. Dr. Cotton, who was lab director, who had done many of the technical reviews, said, this was our protocol, we didn't do it. And while the Commonwealth's position that this goes to the weight and it would have been admissible, the defendant is saying, no, you have to have this confidence interval. This is precisely the type of thing that should have been raised in a motion in limine. And why didn't counsel do it? Because Dr. Bork, his expert, who he spent months getting all the relevant discovery, who gave him a 2-page report, didn't tell him one needed to be done.
Could you just back this up for a little? Is it because of the development of the case law at the time that it needed to be in a motion in limine as opposed to trial, because it wasn't clear that a confidence level interval, or what am I?
Confidence interval.
A confidence interval was necessary in order to make the evidence admissible? Or is that, why did it have to be done at a motion in limine as opposed to having it be part of the foundation that has to be laid for the evidence?
Because the Commonwealth, because even if you presume the principle that all Kernan said at the time was that you had to have, the jury needed to be told something about the significance of the result. And the Commonwealth did that. They did the counting method. It was in the report. And basically what the defendant is now saying several years later is that's not good enough. That's not reliable enough. That's not a frequency, all of which the Commonwealth contested at the post-trial evidentiary hearing. That's precisely the type of evidence, if you in Sparks and Bly, that suggests it should have been done in a motion in limine. And turning back to what Dr. Bork...
Dr. Bork didn't tell, it's paragraph 4 of his summary report. He says a lot of states require this.
As to the SDR, not as to the confidence interval. And that is a big difference, because Dr. Bork was not told... In his testimony, in his cross-examination, were you asked about the SDR statistics? No. Did you feel the need to opine about them? Yes. So in the motion, judge found that counsel, who had spent pains and months making sure his expert had what he needed, made sure his expert didn't have any questions, brought him up to a hearing to discuss the contamination so that his expert could properly advise him, doesn't tell him that he needs a confidence interval. In fact, as to the perianal swab, he talks about, well, you might need a random match probability statistic, which the Commonwealth suggests is completely appropriate. Defense counsel, in this case, did the investigation, and it turns out that Dr. Bork, at this hearing he came up to, told counsel that it was his guy's DNA. And this is a credibility finding. It was a contest at the post-conviction evidentiary hearing of what Dr. Bork said. And the motion judge, who was not the trial judge, but did the evidentiary hearing, found that Dr. Bork told him that it credits defense counsel's testimony. And so counsel, given that information and then said, well, statistics weren't that important to me, that is a reasonable call by defense counsel. Turning now,
Before you leave that, what is your position as to whether going forward we should require a confidence interval for the admissibility of YSTR?
going forward now, it certainly was not error here. Whether it's good practice now or not, doesn't change the fact that this evidence was reliable evidence that informed the jury something of the significance of the result and therefore admissible under Kernan. It's the Commonwealth evidence that a confidence interval only goes to the weight, not the admissibility.
Okay,
Going forward, your answer is,
Weight, not admissibility.
so it doesn't need to be admitted?
A confidence interval? No, that it goes to the weight, not the admissibility of the evidence. Now, it might be given the changes in DNA testing, it might now be a far more fertile area of cross than it was back in 2006.
But going back now to the trial, the claim is that it was more prejudicial than probative. And is your argument that because they had the raw data that was still more probative than prejudicial?
Absolutely. I mean, the jury had evidence that they already saw the profile, that there was somebody else had the profile in that database. And Hickey testified that the profile was going to be the same for all members of a paternal line. And he explained that the numbers only get bigger as the database gets bigger. And if you look at Dr. Cotton's testimony in 2010, the numbers are, her affidavit in 2010, her testimony in 2011, that the numbers in her affidavit, and it's paragraph 25 of her affidavit, which is in the second volume of the defendant's record appendix, it was submitted with the Commonwealth's opposition, that the numbers got bigger, that they got less favorable to the defendant, and as of 2011, it was the same. To speak very briefly on the tapes, this was a regional strategic decision. We're on the tapes sounded, one, not afraid of the defendant. As to the incident that the defendant speaks of, that incident ends with with Weir assaulting the homeless person and the defendant basically laughing about it. The Commonwealth did file a motion to transfer exhibits for the tapes because it's Weir's inflection. It's his very misogynistic view on life that could not be replicated. The Commonwealth would also note, lastly, I believe it's at transcript 8 of 51, that the Commonwealth was complaining that after the defendant was told he could admit the tapes, before the tapes were admitted, that the defendant was only getting in little pieces of the defendant's statement, and the judge said, well, I'll let you read the whole thing after. Weir's statement was coming in anyways, and the tapes only let the very matter-of-fact tone, the use of we, and referring to the victim in a derogative manner be presented to the jury. There is nothing unreasonable about it.
And before I let you go, we discussed YSTR. With regard to STR, is it your view that it was more probative than prejudicial to admit it as it came in?
In the precise context of this case, it didn't cause a substantial likelihood of a miscarriage of justice. And yes, it was more probative than prejudicial. This was a case that the defendant was challenging the investigation. While admittedly statistics were not provided, this was shown as just a step in the investigation of how they got to doing the more limited YSDR testing.
Okay, thank you. And we'll take our morning break.